A number of years ago, I was contacted by a Racine lawyer named Judith Harding Osanka, who passed away a few years ago, and asked if I would work with her in a bill to revise what was then Wisconsin's removal law, which had a number of problems. Judy had a client by the name of Jim Kirkvliet, who was going through a divorce in Racine. And the terms of the eventual order, when his wife sought to move to Florida with their 4 children, was the judge saying that he wished he could prevent the move, that the move was selfish, contrary to the best interests of the children, but he had no legal authority to prevent the wife from moving. I had indicated an interest in revising the removal law, not for the substantive portions of it, but because there were certain procedural areas that needed to be changed. For example, the requirement in terms of filing a notice of intent to remove did not include date of removal or place of removal, which can make a huge difference in cases. There was literally one part of the law where the word "and" should have been "or." Or is it "or" should have been "and"? No, it was "and" should have been "or." And it clearly was just a mistake, but again, possibly could create problems in certain cases. And there were, I don't know, any number of 8 to 10 procedural issues, I'm going to call them, that I had been advocating for change. And Judy contacted me and said, if she appeals the Kirkvliet case and we have an appellate decision saying what the judge did, what she thinks what would happen, would I work with her in terms of getting a change? Because Judy had certain contacts within the Republican Party. Politically, I had contacts within the family law section of the state bar. I met with Judy and with Mr. Kirkvliet to discuss it. Judy did appeal the case. It was affirmed on appeal, and the Court of Appeals repeated what the Racine County judge said, which is that the law should allow the court to prohibit removal under certain circumstances. The problem with removal law, what makes it most difficult, is normally in cases involving placement, assuming there's no extreme circumstances, domestic violence being one, substance abuse being another, alcoholism, mental illness, geography is the greatest problem in terms of negotiating a resolution for both parties, because absent any of those other circumstances, you give somebody an extra Thursday, an extra Friday, you do a 9-5, 8-6, 7-7. It just doesn't make as much difference to the children as it does the parents not getting along and fighting about it, so it's fairly easy to find compromises. That isn't true when geography becomes the issue. When somebody wants to move a long way away, it's much more difficult to find compromises, and it has a far greater effect on the children. Children aren't going to be, in most cases, horribly adversely affected if it's 8-6 as opposed to 9-5 or 7-7 as opposed to 8-6. One day every 14 days isn't going to affect them that much, but if one parent moves to California and the other stays in Wisconsin or in Kirkvliet, one moves to Florida, it makes a huge difference, and therefore the considerations by the court should be different. So I partnered with Judy. We worked and drafted a statute, and after several years of going to Madison and back, getting educated a bit in the legislative process, which confirms what Will Rogers once said, that the two things you never want to watch being made are sausage and laws. We got to watch sausage making laws, and but eventually the statute did get amended. And what it did is to allow the court, under certain circumstances, to prohibit removal, taking into account always the best interests of the children. And it also corrected all of the, or most at least, of the procedural issues which I had, including changing that "and" to an "or," requiring specificity in terms of the removal notices, the time and date. That was about 20 years ago. And in the interim, a number of issues that arose, some of them at the time, some of which come up later, say that this law could be changed and improved upon again. Everything can be improved upon, and certainly this one can. The biggest issue, interestingly, that arose during the process Judy and I were working on the law was the question of whether or not it applies to paternity cases or just divorce. It's very complicated. It isn't a simple issue in terms of it, and it was debated during our drafting, and we decided to leave out the specifics of it because politically we could not get the bill passed if it specifically said it did apply to paternity cases. So we left it out, and it created quite a few issues and battles later, but it was a compromise we made in terms of getting the bill passed, because if we had fought for the issue, and personally I think it should apply to paternity cases. I think there's an equal protection issue in discriminating between cases where parents were married and not married, because there's no interest in terms of the children, better one way or the other. Children don't have a choice whether the parents are married or not, and they're affected in the same way, regardless of the parents' marital status. But we couldn't get the bill passed with that in there, so it was left out. And I've received probably more calls, letters. I was even subpoenaed once to testify into the legislative process of where that is. And some counties now find that it does apply to paternity, some don't, and it's created some confusion over the years. And there are a couple of other issues as well, particularly in terms of what happens in the interim after the notice is filed. What's the court's authority in terms of ordering a temporary removal process? We thought we covered that in the bill, but there aren't any time limits in there. And a few other areas as well that where the law regarding removal can be improved upon. The result is that the family law section has sponsored some legislation that's now pending in front of the legislature, which would clear up many of these issues. For example, it would clearly state that the removal law applies to any case where both parents are granted periods of placement. One of the arguments we had in terms of applying it to paternity cases is that in many of those cases, the father never sees the children, and therefore to prohibit the mother from leaving would essentially imprison her in Wisconsin, where there's no corresponding benefit to the child if the father doesn't see the children. We felt that was pretty easy to cover because a court would grant placement under the circumstances, but as I said, politically we couldn't get it done. This bill takes care of that by specifying that it would apply to any case where both parents have periods of physical placement. So if you have a case where a father, for that matter, a case it could be a mother, doesn't see the children, then the procedures wouldn't apply, and some parent should be free to move, because why not if there's no other parent with placement rights to that child. There are time limits in the proposed legislation in terms of when the courts can have an interim hearing and final hearings about it. I question about how well those work out. In Milwaukee County, for example, it can take 4 months to get a hearing date, and I'm not convinced that in a lot of cases where there are specified hearing times that the courts enforce them as well as they should, but it certainly is helpful to have those in there. And these can be critically important because you deal with, if you have somebody who's applying to remove the children and you're getting into midsummer, late summer, it really is helpful to have those children enrolled in school in the appropriate area. And there are a number of other changes in the legislation that in this new bill, which I think would substantially improve the bill that was passed 1995 that Judy and I worked on. I'm going to give the numbers, and if you have a state representative or state senator who you know, this is a really good time to call them, send them an email, tell them to take a really careful look at this legislation and support it. The Senate bill is 2017 SB 448, and the Assembly bill is AB 551. Again, that's SB 448 and AB 551. The most important thing about this legislation, besides correcting some of the more of the technical or procedural areas and also helping in terms of some of the substantive areas as well, some of the timing of this, is it fulfills what I strongly believe to be the strongest component necessary in anything affecting children in this field, which a lot of our work does, which goes as follows. There are as many varied fact patterns as can be imagined, and then a few that you can't even imagine. What makes the practice of family law interesting is 2 cases are never the same. There's a huge variation, and we don't want to be trying to fit square pegs into round holes by having restrictive statutes which don't let the courts do what is always in an individual case best for these children. Although, as the late Dr. Mary Zozel used to say, it's not what's best for these children in these circumstances, it's what's least worst for these children. So in those circumstances, the court needs to have authority not just to follow the strictures of a statute, but to keep in mind in each individual case is what works best for these children. And this bill does that. It protects the court's authority and ability to do that, and therefore I think this legislation, much as I like to think that what Judy and I did was perfect, it's not. It could use improvement, and this would be improvement on it. So call your state legislature, call your state senator, ask them to support the bill, and in flu periodically when we get updates on the process of the legislation, I'll be providing it so you can keep track of where it's at.